Thank you, Mr. Chairman. Well, I guess I find Professor Busby's testimony on those 5 points actually pretty incredulous. Respect his previous experience and expertise, but the idea that this is a simple definition of the water of the United States, we've heard from people that live, work, and try and build our great country and the economy that that's not the case. This is a vast expansion. Matter of fact, it's not legally responsive even to the courts. Let's go back to the Supreme Court decision, Professor Busby. It was supposed to be about navigable rivers or have some juxtaposition or nexus to navigable rivers. CWA does not include every bloody water in the United States of America. It's supposed to be dealing with those rivers that actually have some nexus to navigability. Otherwise, to the good gentleman from Colorado's point, it becomes a grab of private property throughout the United States of America. That was not what the CWA was all about. I think the fact that this is actually not a broad interpretation is ludicrous. We got 56 different exceptions, and I bet, Mr. Field, are you confident every single exception that they're going to come up with is listed right there? There are going to be some others you're going to run up against?
You're absolutely correct. This is, again, the list. If you follow the 56 pre-approved NRCS practices by the letter, you would be exempt. But if you, again, my offense, not having an NRCS plan, it doesn't meet the standard, I don't fall under the exemption.
Well, and I think that's unfortunately going to be the case for everybody. The Commerce Clause deletion almost is a direct contravention from the plurality's decision in the Supreme Court. You're supposed to still take the navigability piece into consideration. Even Justice Kennedy talks about significant nexus in his decision. There's none of that with the EPA. We're on primary, secondary, tertiary, quaternary, septuagenarial relationships to navigability here. This is ludicrous. I mean, I don't think anybody in a straight face can say that this is anything but a huge grab of jurisdictional power at the end of the day. Let's talk about peer-reviewed research here. I guess I'm a little concerned about how committed the EPA was as they developed this rule to coming up with, the accepted peer-reviewed research when their own EPA draft study, Connectivity of Streams and Wetlands to Downstream Waters, a review and synthesis of the scientific evidence, was sent to the EPA Science Advisory Board to begin review on the same day they sent their final rule to OMB. I mean, if you're talking about peer-reviewed science and actually watching science, they don't even follow their own gall-darn science. I mean, that's an indictment that I think is beyond the pale here. All I know is that back in Oregon, we have a lot of federal land, just like every western state legislator here. And we have a tough time dealing with all the federal rules on a regular basis. And what we're seeing here is, unfortunately, more rules, more regulations. I think Mr. Park summed it up nicely. More cost, more delay, more uncertainty. Even if it doesn't go to lawsuit, Professor Busby, not every dang small businessman has a lawyer in their pocket that they have on retainer that they can fight these things. The threat of someone driving down the highway, seeing a practice, and they're worried about it, all of a sudden you've got EPA, or my state, DEQ, coming in, investigating you. That costs a business money. This is an abomination. Thank you, Mr. Chairman. I yield back.